The trial on hush money was Trump's to lose. This is the reason he did. Although the guilty conviction against Donald Trump by a New York jury astonished the world, some people who closely followed the case weren't taken aback. Prosecutors had the burden of proof, so Trump had to lose this case. Attorneys and former prosecutors told the BBC that the defense was hampered by his team's inability to present a counter-narrative and their poor approach to exposing the vulnerabilities in the case. And one thing had already set up a difficult battle for them before they had entered the courtroom. Civil litigator Mitchell Epner of New York stated that the defense's biggest issue in this case was that Donald Trump was their client. An absence of story. The jury had to find that Trump had fabricated his financial records and that he did so with the intention of covering up or committing another crime in order to find him guilty. In order to prevent Trump's 2016 campaign from collapsing, adult film star Stormy Daniels was paid $130,000 by her former attorney, Michael Cohen, with Trump's agreement to remain silent over an alleged sexual encounter. This is how the Manhattan District Attorney's Office's case played out. After that, Trump gave his approval to a fictitious plan that would pass off Cohen's payment as legal costs in order to conceal the hush money. Prosecutors claimed that because of this, he violated election laws, committing election fraud, pure and simple. The prosecution then introduced 20 witnesses and presented numerous important documents, including checks signed by Trump to Cohen. Regarding the 34 counts of falsifying business documents, Trump entered a not guilty plea. However, after 30 years of service as the Manhattan District Attorney, John Moscow stated that the defense never had a story that the jury could accept. Giving the jury a good explanation for Trump's repayment to Cohen, for instance, would have aided the case even if they were not required to refute the prosecution's assertions, according to experts. Todd Blanche, Trump's lawyer, offered a different justification for the forged documents during his closing statement. According to him, they were reimbursements for real work Michael Cohen completed in 2017. Therefore, classifying them as legal fees was legitimate rather than false. Additionally, the defense claimed that Trump paid Ms. Daniels merely to keep his family safe and not to trick voters. But Mr. Epner said the team never pursued that line of reasoning. According to Mr. Epner, they never chose a lane, and because Donald Trump blocked off every lane that could have been picked, they attempted to confuse the jurors by flinging dust in the air. Omitting the important detail, Randall Eliason, a professor at George Washington University Law School, told the BBC that while the prosecution produced extensive data to demonstrate fabricated corporate documents, there was thin to non-existent proof that Trump genuinely meant to commit or hide that crucial second felony. Although Mr. Blanche provided the jury with a variety of reasons for reasonable doubt in his summary, Trump's team did not concentrate on highlighting this shortcoming. Rather, they contended that either the witnesses had lied or the case's major events never occurred. Yet, the jury might have concluded that the testimony and further evidence did not back up these allegations. A stronger defense, according to Mr. Eliason, would have been to assume for the sake of argument all of this happened. Trump was aware of the hush money scandal and the sex incidents that took place. All right. That is not the nature of the charges. What proof exists that Trump actually intended and knew this? That's where the case is deficient. Susan Nachiles, the lawyer for Trump, attempted to paint Ms. Daniels as a liar who was only after money and notoriety for her claim throughout her cross-examination. Professor Anna Kaminsky of New York Law School stated, "It's a surprise to no one that there was probably a lot of pressure from the client to paint certain people as liars." It's not always the ideal defensive tactic. For the defense to prevail, Stormy Daniels did not need to be a liar. The Cohen component, discrediting Cohen, a prominent witness, was the defense's best chance of winning. Over the years, Cohen undoubtedly produced a lot of fodder: guilty pleas for crimes including lying to Congress, incessant public criticism of his former employer, and inquiries into whether he had lied to a judge. Mr. Blanche emphasized these ideas. He referred to Cohen as the greatest linger of all time, or the gloat, in his concluding remarks. He seriously questioned Cohen's claim during the trial that he had called Trump on October 24, 2016, regarding hush money while the president was using a bodyguard's phone.
According to MS. Kaminsky, I thought that was a huge win for them, potentially catching him in a flat-out lie or misremembering. However, the defense also committed a few mistakes. The first substantive question, Mr. Blanche asked Cohen was a direct one. You went on TikTok and called me a crying little shay, didn't you? Cohen said, sounds like something I would say with poise. In a sidebar, Justice Juan Merchan chastised Mr. Blanche. He questioned, why are you making this about yourself? It was an incredibly awful moment, Mr. Etna remarked. He was thoroughly defeated in a high-noon showdown. Only one significant witness, attorney Robert Costello, was summoned by the defense to refute several of Cohen's assertions. However, Mr. Costello's own emails refuted his testimony, and in an odd and tumultuous moment, a furious Justice Merchan cleared the courtroom to chastise Costello for his actions during the testimony. The situation is what it is. However, not all attorneys thought the defense had much options. Karen Agnifilo, the chief assistant district attorney at the Manhattan DA's office until 2021, stated, I'm not sure they did anything wrong. This is the case as it is. Others claimed there was substantial proof connecting Trump to the crime. Mr. Moscow stated, people get convicted on evidence a great deal less secure than this. However, not all legal experts believe the prosecution's skill at law won the case. Jed Sugarman, a professor at Boston University School of Law, who describes himself as politically progressive, believed that the charges of election fraud were overblown for political purposes and that the underlying offences that should have been charged as felonies were never made clear. He thought that presenting the case in a liberal jurisdiction and picking a favourable jury were the keys to the prosecution's success. According to Mr. Sugarman, Trump's mistake is doing crime-like stuff in Manhattan,